very briefly. So accommodation requests related to COVID-19 that you need to be aware of, I've got them all listed here on the screen. So that's employees over the age of 55 whom the CDC has determined are in a class where they present a higher risk of complications from the infection. And any employee that has a medical condition that otherwise puts them at high risk, diabetes, heart conditions, things of that, and also pregnant workers, employees who cannot wear masks due to a medical condition or a religious belief are going to fall under this category, and also those who may need enhanced PPE or need to telework. Other claims that we are anticipating seeing is a failure to engage in the interactive process and failure to prevent disability discrimination. So my recommendations to stay compliant and avoid these accommodation-related lawsuits is document all requests for accommodations and take them all seriously. Whether it's someone who's just fearful for coming into work, put it in writing, keep it documented, engage in the interactive process, and document each step of that process. Be sure to train your employees on how to recognize when an employee is making a request and how to appropriately respond. Consistent approaches when responding to the requests. You want to treat similar employees in the same way and don't single out higher risk employees. For example, do not preclude employees from returning to work just because they are over 65 years old or pregnant or may have a medical condition that otherwise places them at a higher risk for complications.
I wanted to discuss this case that came out of Massachusetts. It's not binding on California employers, but I thought it was indicative of what we might be seeing coming up here, future litigation in terms of accommodation requests. In this case, the EEOC filed a lawsuit against Baystate Medical Center alleging religious discrimination. The employee at issue claimed that her termination was due because of religious discrimination because she refused to take a flu vaccine. The employer had a legitimate interest in minimizing flu among its employees and spreading it to customers and clients. So they said they mandated that the employees get a flu vaccine, and if the employees did not get a flu vaccine, they were required to wear a face mask at work. And then the employee refused to get the vaccine, so she was wearing a face mask, but then she failed to wear the face mask all the time at work, so the employer terminated her. That resulted in the lawsuit. The employer was able to get this case dismissed, and the judge said, look, this wasn't a motivating factor, wasn't the employee's religion. There was, they required either you get the vaccine or you wear the face mask. And the fact that the employee was not wearing a face mask and they were terminated for that reason was not related to the employee's religion, the court found. And the employee also raised objections about what the effectiveness of wearing a face mask in the workplace was and things like that. But the court said, look, we're not going to second guess the employer's requirement. It doesn't matter if they're effective in the workplace or not. The fact that the employer required the face mask if they didn't get the vaccine was within the employer's purview. And if the employee did not abide by that requirement, and then the employer was open to terminate the employee for that reason. So I wanted to raise it as some potential issues coming up. We're going to probably see some vaccine if we do have a vaccine for the coronavirus and how this might play out as well in the future. So wanted to raise that issue, but it is important though that we might see some religious types of claims or reasonable accommodation, medical reasonable accommodation issues coming up. You need to keep your eye on that as we're getting back into work here with the coronavirus.